Good morning, good afternoon, good evening, wherever you are. Welcome to everyone to the launch event for BIICL new project on global perspectives and corporate climate legal tactics. My name is Ivan Alonia. I'm the research lead in environmental climate change law at BIICL and the project lead. And I'm delighted to introduce you today to this new exciting adventure. So today I'm connecting from COP27 in Egypt, and I have the great honor of being joined online from other continents by some of the most renowned legal experts in the field of climate change litigation, all parts of the project core group. Many thanks to Jackie, Jap, and Richard. But before leaving the floor to our chair, Ingrid Goubet, who is going to introduce them and starting the discussion on this topic, let me just provide you with some elements to present our project. Next slide, please. So just a few weeks ago, the Mission Gap Report 2022 was published by UN Environment. You see this on the top right corner of our slide. This finds that the international community is failing far short of the Paris goals, with no credible pathway to 1.5 degrees in place. Only an urgent systemic-wise transformation can avoid climate disaster. This always more evident failure by national and international policymakers has required other actors to react in order to tackle climate change. And so climate change litigation has become an increasingly fundamental component of the governance framework that has emerged to regulate how states respond to climate change at the global, regional, and local levels, exerting pressures on the executive and legislative branches of government to act on climate change issues. More than 2,000 climate change litigation cases have been filed globally today, according to the climate litigation databases hosted by the Sabin Center for Climate Change at Columbia University and the Grantham Research Institute on Climate Change and the Environment at the London School of Economics. While around 3/4 of these cases have been filed against states, climate change related cases have also been filed against private actors, mostly carbon majors, so fossil and fuel cement companies, which are major greenhouse gas emitters. They were already identified in 2014 by Richard Heady and the Climate Accountability Institute to an assessment of the historical contributions of these companies to greenhouse gas emissions. Rick Heady attributed 63% of the carbon dioxide and methane emitted between the years 1751 and 2010 to a mere 90 entities. Although there is a growing body of work analyzing climate litigation from a comparative perspectives, including, as you see on the left part of the slide, a recent edited volume by BIICL, the analysis of the peculiarities of cases involving corporate players has yet to receive the same rigorous attention. So we must add just that this year, for the first time, the Intergovernmental Panel on Climate Change has recognized that climate change litigation can affect the outcome and ambition of climate governance. Next slide, please. So to introduce a little bit the project, this project will produce a mapping and a comparative analysis of corporate climate litigation cases globally, examining causes of action, remedies sought, and procedure used, and taking into consideration perspective from 17 countries in both the northern and the southern hemisphere. The idea is to offer a comprehensive overview of both the existing best practice worldwide and the most suitable corporate climate litigation avenues for differentiated legal systems and economies. This project also will catalog existing cases, and it will take stock of the lesson learned in other fields. For example, tobacco, asbestos, toxic torts kind of litigation. And it is going to engage in strategic, prospective, and interdisciplinary thinking, identifying possible frameworks, arguments, and legal instruments to tackle climate change. It will also help litigation planning. It will contribute to more comprehensive, we hope, and effective climate action, And also it will hopefully raise public awareness, and eventually, as a consequence of its deterrent effect, it will allow and encourage corporate actors to mitigate the litigation risk by changing business behavior. In view of this objective, the project, as I say, will provide global perspectives on corporate climate legal tactics with a selection of tools for NGOs, government bodies, and local communities, as well as other affected groups, individuals around the world, and of course, those that are representing them. It will contain an inventory of substantive and procedural provisions relevant to climate change cases to be used as legal models by policymakers and legal practitioners, and also it has the ambition to act as an authoritative reference point for judges and other adjudicators. Next slide, please. So this is a little bit the structure of the people that are working in this project. So the research and the content analysis is carried out by the British Institute of International Comparative Law and its climate change research team, but also many other parts of our institute with fellows from other areas, very interdisciplinary kind of project, as I was saying. And of course, there will be some national rapporteurs that will be hired from each of the selected jurisdictions. As you can see, there will be a core group. You will hear from some of the members of this core group in a minute. So this core group and a wider international expert group are the foundation of our project. So the core group, as I said, is comprised of some of the most international renowned experts from around the world in the field of corporate climate litigation and related areas, drawn from science, the judiciary, legal practice, and academia. And we have also this international expert group, which will be built around and to support the 17 national rapporteurs from the country that you see on the slides. So we are covering for this first year 17 jurisdictions in each continent, and the international expert group will be the role will be to complement the capacity, the expertise, and experience of the national rapporteurs with the exchange, dialogue with practitioners, scientists, judges, other experts in the field. So this is also the moment to say, if you want to join us, if you are interested to work in this project, please contact us, because we are still in the process of creating this international expert group. So next slide. These are the project activities. So as you see, to start, that this project will be on 2 years. Year one will be on research, drafting, and of course there will be the publication of the report, which include all our findings. So as we call a sort of toolbox on corporate climate litigation. We are starting in this moment with the creation of this international expert group, but then we will have quite soon in January, we will have the first round of a country workshop. Thank you, Ingrid. The first round of a country workshop in which we are going to discuss, each national rapporteur is going to discuss the research preliminary findings with, as I say, the rest of the international expert group from that country. So providing elements, suggestion for improvement. Then, of course, in February, we are going to organize a plenary, hybrid, virtual and in person, of course, as you can imagine, also for reason that we can imagine working on a climate change project. Is going to be a hybrid workshop for the person that are in London, but if not, is virtual, organized on this topic. The event is going to be the opportunity to support the development of the comparative analysis at the basis of the project, and also to discuss in a cross-sectoral way the findings, testing against the lesson learned from other relevant areas of work, as I was saying, all the other kind of litigation that we experienced in the last years. Then we will have, of course, the national reports quite soon after that. And we will start in the spring a series of three comparative workshops on the research axis, which, as I said, are the causes of action, the procedures, causation, and of course, the remedies. And this is what will give then all the work, all the material to create our toolbox, and that will be published, of course, in early autumn. Just to finish, just a short overview of the second year, which will be more based on testing, promotion, and dissemination of our findings. So, of course, we are going to organize several events. We are going to have several outputs. We will have these 5 regional summits, one for each continent, in collaboration, of course, with our international expert group, with the core group members. The idea is in the second year to add further legal system and experience into this discussion on corporate climate litigation, and to explore also some further comparative suggestion and option for utilizing these kind of tools on a global level, and also raising awareness of its potential use. And then, of course, there will be judicial briefing. We are going to organize a corporate climate litigation course. We are going to create also a new corporate climate litigation database, which complement the already existing one in New York, in London, and in Melbourne. And we'll try to have a comparative translation kind of database, but we will have time discussing about this. And many other outputs, of course. And now I leave the floor to our chair. I'm going to introduce to you Ingrid Goubey, head of the Human Rights and Environmental Law team at Hausfeld, and also our new visiting research fellow at BIICL. Thank you very much, Ingrid. You have the floor.
Thanks very much, Evaldo, for introducing such an ambitious and it's going to be a very helpful, I think, project. We are honoured, of course, to have with us today 3 very long-time eminent experts in this field. And no doubt they will be known to many of you in the audience. They're also members of the core working group on the project, and their full bios, if I miss things, are up on the BIICL website. So feel free to also peruse all of their publications. Each of them will speak for 15 minutes, and that will be followed by a Q&A. So if you want to send your questions in the chat, we'll pick them up as we go along and answer them at the end. The first up, speaking from Australia, and it's around 9:45 or so there in PM. So we're very lucky to have Professor Jacqueline Peel with us. She's a leading internationally recognised expert in the field. Her scholarship on the topics encompasses international, transnational, national dimensions, as well as interdisciplinary aspects of law-science relationship in environmental field and risk regulation. She's currently Director of Melbourne Climate Futures, the university's climate change initiative, and she's been an active contributor to national and international policy projects. She's also authored several significant books, including The Principles of International Environmental Law, both the 3rd and 4th editions with Philip Sands, and most recently, she served as lead author on the Mitigation Working Group 3 of the IPCC. And today she's focusing on the gaps and barriers to bringing corporate climate cases in Australia, and how risk-based disclosure instruments are shaping corporate behaviour, interdisciplinary aspects of the law-science relationship and attribution. And if there's time, she'll touch on where we are at COP on the loss and damage issue, which is going through hard negotiations today as we speak. And she will be followed by Richard Lord, KC. And those unfamiliar with the quirks of the English legal system, when the late Queen died, all the QCs became King Counsels. So he's now a King Counsel. And Richard is the chair of the Action for Justice Governance Group and A4J board member. He's a barrister. He's very at home in the commercial courts, a commercial litigator. He specializes in shipping, shipbuilding, insurance, reinsurance, insurance being incredibly topical right now as well. and he's appeared in numerous cases in tribunals from Supreme Court, House of Lords to the High Court in the British Virgin Islands. His particular interests are maritime insurance, environmental and climate change law, and he's co-authored a book I've often read and referred to, The Climate Change Liability, Transnational Law and Practice. And he's going to focus today on the general barriers to claims in the form of non-justiciability, illustrations of those being overcome in Shell, and also refer to Peruvian farmers' case, pushback in common law jurisdictions, as per Smith v. Fonterra, and a bit about causation, and possibly touch on RWE versus Netherlands. And those two speakers will be followed up with a good roundup from Professor Jaap Speer, who many of you will know. He was a former Advocate General in the Dutch Supreme Court. He holds an honorary chair at Global Challenges of the University of Stellenbosch in South Africa. He's a senior associate at University of Cambridge Institute for Sustainability Leadership, and he's senior fellow at Global Justice Program at Yale University. He has also co-authored a book called Climate Change Remedies, Injunctive Relief and Criminal Law Responses, which have no doubt will be incredibly useful. So without further ado, I'm going to hand the floor over to Professor Jacqueline Peel. Thanks, Jackie.
Thanks very much for that introduction, Ingrid, and also to Ivano for painting the scope of what I think will be a really important project in this area. I'd just like to begin, because I am here in Australia, by acknowledging that I'm speaking to you from the lands of the Wurundjeri Woi-wurrung people of the Kulin Nation, and I pay my respects to their elders past and present, and extend that respect to any First Nations colleagues or peoples who are joining us here on the webinar this evening my time, this morning and this afternoon in other time zones. As Ingrid said, I'll speak in my comments to three main issues, reflecting on the experience of bringing corporate climate cases in Australia, which has really been a bit of a pioneer jurisdiction for this area of climate litigation. I'll then turn a little bit to think about the ways that corporate behaviour is being shaped by the developments around climate risk, and particularly the reporting standards emerging in that area. And then reflect on the interdisciplinary aspects of the law-science relationship, particularly as it pertains to questions around causation and attribution, which are a key part of many litigation claims. And if there's time at the end, I'll also just reflect a little bit on the COP27 loss and damage negotiations that I've been monitoring from afar, and how they intersect with possible litigation claims. So starting with the context in Australia, Australia is distinguished by having a very high number of climate cases overall. In fact, the second highest number of cases globally, second only to the US. And this has been driven in many respects by a poor policy response at the national level for many years, which has encouraged environmental groups in Australia, particularly, to seek other remedies to encourage more ambitious climate action. In 2019, myself and colleagues wrote a paper reflecting on the Australian context, where we talked about the possible emergence of a next generation of climate cases in Australia. And we were thinking about the change that we were seeing between cases that focused mainly on challenging projects, usually with governments as defendants, to a new wave of cases that we saw on the horizon, one of which being more claims against corporations to try and achieve accountability for the harms that they might be visiting on the climate. And that prediction has proved to be true in Australia, in the sense that we've seen an emergence of perhaps not a wave, but certainly the beginnings of ripples outwards of a number of corporate climate claims. In Australia, those have focused mainly on questions of climate risk disclosure, with a focus on private sector actors like banks, like pension funds. In Australia, they're called superannuation funds. and also on other corporate entities. One of the features of the Australian climate litigation landscape around corporate claims is that we haven't seen a sort of carbon major type claims. We haven't seen direct challenges to companies suing them for compensation or a finding of liability in respect to the harms caused by their emissions. And part of the reason for this is because that tortious claims based on a duty of care, have not attracted the same support in Australia as they have in other jurisdictions. And I think my colleagues on the call might speak to some of those other cases, for example, the case of Shell. So in Australia, there have been attempts to bring duty of care cases, particularly in a recent case of Sharma. That was not a corporate case. It was a case brought by young children in Australia against the federal government, which was seeking to extend a new coal mine. And the argument put by the children was that there was a duty of care on the minister to ensure that any decision that she was making was having regard to the interests of those children, and the fact that the children and future generations could be harmed by climate change contributed to through activities like coal mining. That case was successful at first instance, but then overturned on appeal. And it looks like that avenue of duty of care as a direct way of holding companies to account in the Australian context will not be successful. So what we're seeing in the Australian context in terms of the tools that are being used for corporate climate litigation is a focus on corporate law, a focus increasingly also on consumer law that might be able to hold companies to account in terms of the kinds of disclosures they make about climate risks, the way that boards and directors are managing those climate risks, and increasingly on the horizon, the possibility for greenwashing claims using consumer laws where there's circumstances, for example, where claims are made about being carbon neutral or delivering on net zero targets or gas as a clean green fuel. These kind of claims being increasingly targeted also as part of the litigation landscape in Australia. So that's a bit of a quick overview of some of the corporate climate litigation developments we're seeing in Australia, not the duty of care claims, but a very favourable environment for some of the corporate law claims, and indeed also potentially class action claims, because we have quite a liberal class action regime here in Australia too. Second, turning to this question of how corporate behaviour is being influenced generally by this ideas of climate risk, which obviously is motivating a lot of the cases to call for better climate risk disclosure. There's really been a shift globally since the Paris Agreement, really, to see climate change in terms of not just an ethical or environmental matter or risk, but one that has financial consequences. And we've seen that particularly through the work of international organisations like the Task Force on Climate-Related Financial Disclosures, setting standards that really have inspired other standard bodies now to begin to issue these kinds of standards, whether at the national level or international standard setting bodies, and a movement towards climate risk reporting becoming mandatory in many jurisdictions. That hasn't happened as yet in Australia, but there's a general acceptance or mainstreaming of the idea that climate risk is a material financial risk for many companies, particularly those in energy intensive areas like coal mining or energy production, and that those risks need to be taken into account in management decisions. Finally, just on the interdisciplinary aspects of law science and causation, this is a big issue, but Ingrid's flashing a 5-minute sign at me. So I'll just say on this area that really in terms of some of the bigger corporate claims that might be on the horizon, the claims against carbon majors. The holy grail is really that around establishing causation, a link between a particular company's emissions and particular climate harms. And Richard Heady's work that Ivano mentioned has been incredibly important in beginning to sketch out the relationships that exist there. But in terms of the developments of the science, we're also seeing much greater capacity for attribution between increases in emissions and particular extreme weather events, with heat waves and, in Australia, bushfires or wildfires being particularly a clear relationship between rising emissions and those harms. Just finally, in relation to the loss and damage negotiations, I think that in many ways these have become the key litmus test for this COP. A lot of the negotiation is, of course, focusing on whether there will be a fund established to provide loss and damage compensation, or at least a facility to allow funding to go to climate ravaged countries to assist with their reconstruction costs. In many ways, the question of liability and litigation is bracketed off from that discussion. It was so when it was put on the agenda. It was separated out, that there wasn't going to be a discussion around liability and compensation. So really the relationship between the loss and damage negotiations and corporate climate litigation, or liability more generally, is one perhaps of cause and effect. If we don't see significant progress on loss and damage funding under the regime of the Climate Convention, then we might expect to see, as a reaction, more exploration of claims in climate litigation, either domestic or international. And some of those definitely could also be taken against corporate major polluters. So I'll stop there, Ingrid, and look forward to the rest of the discussion.
Oh, Jackie, that's absolutely brilliant. And I'm hoping that you can stay around, because I think there'll be questions. Thanks so much. Richard, we'll move to you now in the UK. Please go ahead.
Thank you, Jackie, and thank you, Ingrid. Yes, where do I start? Because there are so many interesting questions for lawyers, which of course reflect into questions for policymakers. But I'm going to reflect primarily on the notion that climate change cases generally, and particularly those in relation to corporate liability, are non-justiciable. Now that word can mean all sorts of different things to different people in different jurisdictions, and but the general notion is that climate change cases are sort of special case from other environmental or similar type cases, and because of the international nature of the problem and the rather unusual aspects of cause and effect of damage, somehow they should not be for the courts. And the overarching theme is this is too big a subject, too difficult a subject to be dealt with by the courts. It should be dealt with by international regulation. And as a matter of principle, of course, few people would disagree with that. Litigation is a blunt instrument and it's not going to solve climate change. But of course, the problem is, as most people recognize, is that what international regulation has been able to deliver so far falls way short of what the science says is necessary. So what does non-justiciability mean? And it tends to break down into a number of sub-doctrines. And again, I don't want to get into all the terminology of different jurisdictions, but one strand is this idea that the court should not interfere in what's a political question. And that's because it requires courts to exercise value-based judgments, which isn't their sphere, it's the sphere of policymakers and legislators. And that was a big element in the rejection of a number of what I might call the first wave claims against corporates in the early 2000s in the US. And then there are some related strands, which often it's put on the basis of standing. So usually these claims are brought by an NGO or sometimes individuals, and it's said, well, they're not really the right person to solve this question. Again, it's a sort of another facet of the argument that this should be dealt with by regulation. And it's often said that either the claimants themselves have suffered insignificant damage in the scheme of things, or that they'd suffered no more damage than any other of the about to be 8 billion citizens in the world, and thus that they don't have standing. The flip side of the argument that it should be for international regulators is what's sometimes known as the preemption or displacement approach to non-justiciability, again, featured quite heavily in the US, but elsewhere, which is saying, well, actually, it is covered by existing laws. There are more and more climate change acts and regulations, and therefore there should be no space for more direct actions against corporations. It should be dealt within the framework of existing laws. And again, the simple answer to that, to the extent there is an answer, is no, the two can coexist, and that other than situations where a piece of legislation expressly excludes other remedies, the two coexist together. And as the lawyers listening may have gathered, some of these aspects that I put under broad heading of non-justiciability could be pigeonholed into different legal categories, discretionary factors that appear at many stages in the English law, certainly have taught, but I'm dealing with them in this way at the moment. Similarly, it said, well, there's no effective remedy that we granted. Either the remedy is too vague, just to reduce emissions, or it's not going to have any real effect, and so on and so forth. Also, you get wrapped up in aspects of non-justiciability, questions of causation, and this overlaps with questions of standing. It said, well, this particular person is claiming that there's damage by a corporation, but it's such a tiny drop in the ocean of the global problem that, again, this shouldn't be from the courts. And there's a sort of more broad general catch-up provision where courts have a discretion as to where they should hear a claim, even where they have jurisdiction. This idea that it should be not exercised where the courts have a discretion. And a lot of these arguments have had considerable traction. There's some very learned studies about comparative approach in Canada and the US and so on. And it's fair to say, I think, that Paris was a game changer, not because it required states, let alone corporations, to do anything specific, because it didn't, but because it provided benchmarks against which standards could be examined, whether they were states' approaches or whether corporate policies were aligned with net zero. So moving on to the second of my 5 bullet points, the first being barriers in the form of non-justiciability. Well, are they being overcome? And it's fair to say that although one can't generalize, the European courts have to date had much less hesitation in saying, no, we can and will exercise our jurisdiction in this regard than some of the common law jurisdictions. And the starting point, of course, that paved the way was not a corporate case, it was the agenda case. But a lot of these same arguments were raised in relation to the suit against the government. And as probably everyone on this webinar knows, those arguments were unsuccessful and the state of Netherlands was ordered to reduce its emissions. And that was groundbreaking in that it went in terms of action against a state that was beyond just judicial review. But then the most important case, I think, is one that, again, probably everyone is familiar with, but I think it genuinely deserves that much overused tag of a landmark case, which is the Shell case, because that moved the arena to that of corporate accountability. And the claimants there, I still can't pronounce it, Milia Defensie and others, NGOs, relied on the Dutch general law of a duty of care in Dutch law to require 40%, 5% reduction. And Shell, unsurprisingly, said, no, this isn't for the courts, and it's being dealt with at a national level. And it rolled out all the non-justiciability arguments, or a lot of them, in a way that time doesn't permit me to summarize. But the court gave it very short shrift. It said, it does not follow the argument that it is beyond the function of the court. The court must apply the law as to duty of care to Shell and to climate change cases just as it would, it didn't use these words, as if it were a road traffic accident or anything else. So it's saying, no, there's nothing special about climate change. There may be factors that inform the standard of care and the remedy, but there's nothing special. And that was incredibly important. And it dealt with the question of standing of the claimants to deal at least with damage in relation to the Netherlands. It gave some broad guidance about the legal or the standard of care being informed by the UNGP and applying to all enterprises. It stated that scope 3 emissions were within that, and it upheld the complaint and made a ruling which did, I think, reverberate around the world in all sorts of places, policymakers, boardrooms, and others. Just touch on a couple of other cases which are also interesting. The so-called Peruvian farmers case, Liuana, that's interesting in a number of ways, but first of all, there the German court rejected these arguments in the case of a Peruvian farmer, saying that RWE was responsible for a share of the cost of remedial measures caused by climate change in Peru. And again, this is, I think, still in the evidential phase, but the challenge has been thrown out. And what's interesting, there are lots of interesting things about this case, but what is interesting is that most of the litigation, even the litigation against corporates, is prospective. It's looking at injunctive relief to change behavior going forward. And this one is actually seeking compensation based on the 0.4% share which the claimant says RWB is responsible for in terms of global emissions. And so that's another example, non-justiciability arguments not being upheld there. And finally, while we're in Europe, then we have Notre Affaire and Total, where Total is being sued by an NGO in reliance on the specific French due diligence law. And again, the court has said it's got jurisdiction to entertain that claim. So third point, well, common law, I've learned before not to confuse Australians with New Zealanders, but going back in Jackie's general directions, New Zealand Court of Appeal and Smith and Frontera, basically completely opposite there in the Court of Appeal decision. And I quote, the Court of Appeal, this was a case where various people sued New Zealand's largest emitters, corporate emitters. They weren't big on the scale of the carbon majors. And the court, before it gone to an analytical approach to the elements of the torts of negligence and nuisance, it basically said, look, we're washing our hands of this. This shouldn't be in this court. They said, in our view, the magnitude of the crisis, which is climate change, simply cannot be appropriately or adequately addressed by common law tort claims pursued through the courts. It's quintessentially a matter that calls for a sophisticated regulatory response at a national level supported by international coordination. Now, there's a huge amount I could say about that. but won't. But they picked out this idea that basically every global citizen is both the potential claimant and the defendant. The remedy won't be effective. Climate change is an inefficient response. Lots that could be said about that. I believe permission is being sought to go to the Supreme Court, but this tension between that approach and the European ones. So in what is probably my final 2 or 3 minutes, first of all, touch on elements of causation. And it used to be thought that causation was an insuperable problem, because how do you show the link between emissions and climate change, and then climate change and individual damage? And the lawyers were very used to talking about things like but-for cause and effective cause as opposed to material contribution. But the agenda and Shell case have shown that's not an insuperable point. The fact that even the biggest emitters are responsible a small amount of damage, climate change, and climate change itself is only contributed to extreme weather events. And so watch this space. And even the English law has itself shown itself flexible and going beyond the but-for case, even in things like business interruption insurance cases related to COVID. So I'm not saying causation isn't very important. There's lots to come on that, but it's not seen as this barrier. And the final point I want to make is maybe slightly outside the scope of this seminar, but it's an important point, because what's happened as a result of, or in partly as a result of the Dutch decisions, well, the Netherlands are dutifully bringing in climate acts and banning coal. So what happens? We have people like RWE bringing claims against states under either the European Energy Charter Treaty or, in other cases, bilateral investment treaties, saying, well, hang on a minute, they basically say in this case, under the Energy Charter Treaty, well, hang on, Netherlands, in 2015, you're encouraging to invest in coal. You've now banned it. We've lost $1.4 billion as a result of diminution in value of our investment. And you should compensate us under various provisions of the Energy Charter Treaty, which reflect business investment treaties worldwide. Concepts of fair and equitable treatment, concepts of expropriation of assets without adequate compensation, and various other things. So I bring this up because it's an important thing to bear in mind. So, corporate may be found liable by virtue of various strategies, but they then may try and bring actions for redress against that liability in other fora. So that's a very quick canter through a few aspects of this, which I think are interesting and important. These concepts are going to be, I think, all high on the agenda of litigators, whether on the claimant or defendant side, in years to come. And my final 10 seconds, if I've got those, one of the predictions that we made in our book 10 years ago is that don't just look at Europe and the US and Australia, look for developing country courts. And that, I think, is going to be a place to watch. It will be very interesting and is already interesting. I will now stop, but thank you very much for listening patiently to my 15 minutes. Thank you, and back to you, Ingrid.
Thanks, Richard, and a great note to finish on. Yes, the Global South courts are incredibly robust at the moment and have been for a while. So yeah, I agree. Yeah, Professor Jaap Speer, please. We're very keen to hear your thoughts on the project, etc.
Well, thank you very much indeed. In his autobiography, the latest UK Labour Prime Minister wrote, "The only way the Progressive Party can succeed is by being both radical and credible." And that, I'm afraid, is the dilemma we are facing time and time again. To strike a balance between the hugely diverging interests. Radical solutions are necessary, but not credible. Credible solutions are rarely enough. We all know that global emissions are still rising. The carbon budget is depleted at very great pace. In spite of the urgency, there is no, I mean no, appetite to enter into meaningful discussions about the legal obligations of enterprises. In spite of the many distinguished endorsers, the real world is not interested in initiatives that tried to map key obligations, the principles on climate obligation of enterprises. Hence, enterprises don't have a clue what they are obliged to do, and others can't assess whether they do enough. Understandably, NGOs are increasingly focusing on litigation, and others are follow suit. Litigation is not only important, it's increasingly unavoidable and necessary to bring laggers to their senses, to get a better understanding of the law, and to explore the most promising avenues to reduce global emissions. And this is a tremendously useful project. It will contribute to our understanding of the legal hurdles, opportunities, which claims stand a favorable chance before which courts, the most promising remedies, the most promising legal basis, the most promising plaintiffs and defendants, the reason why claims are rejected or the relief sought was granted. Can successes be replicated and failures be avoided in the future? Which arguments, not necessarily only legal arguments, appeal to courts? Choices should be made in a keen understanding of the facts, which is rarely happening actually. What is the upper limit of the rise of global temperature still within reach? The current debate still seems to believe stupidly that's 1.5 degrees. Forget about it. 1.5 is no longer within reach, and we know it. The current debate is still, we still have 30 years. That's not true, and we all know it too. We don't have 30 years. Don't ask me how many years we do have, but it will be significantly less than 30 years, and that's important. That's also important for the right claims and the right judgments. I already mentioned that we have to strike a fair balance between pragmatism and ambition. And that is far from easy. Developing countries have many people who don't have access to clean water, proper shelter, education, medical care. In my part of the world, we believe that we are entitled to luxury and that it is crazy that we should give up at least part of it. It would be utterly reasonable to require a hell of a lot from developed nations and enterprises in affluent states. Also, if that would mean a lower standard of living. However reasonable, it will be necessary to convince courts that that is a reasonable position, and that will not be very easy. There's a lot of debate about what I unrespectfully call fashionable features, the rights of and obligations towards future generations, the right to a clean and healthy environment, and the rights of nature. I don't dispute that they are important, but there is so little discussion about what that means, and we need that discussion, otherwise those features can't be translated into meaningful basis for litigation and judgments. And then two concrete examples. First, the case was already mentioned, the Peruvian farmer versus RWE. The case and the claim is often hailed as groundbreaking and brilliant. It's certainly groundbreaking, it's not necessarily brilliant. The debate is largely based on one-liners. Contrary to the prevailing view, far-reaching liability is likely detrimental to vulnerable countries, vulnerable people, and the environment. A penny can only be spent once. Far-reaching liability could mean, and probably will mean, those who reap the fruits of excessive emissions will also reap the fruits of far-reaching liability. And that would be turning things upside down. I'm not saying that liability should be a non-starter. I'm saying that it should be confined to those who need it most, i.e. vulnerable countries, people in those countries, and the environment. I would love to go into much more detail, but time doesn't allow me to do so. And then the case was also already mentioned, Milieu Defensie versus Shell. Thanks. The District Court of The Hague granted injunctive relief in that Shell has to reduce its scope 1 emissions, scope 1 emissions of the entire group of companies with 45% in 2030 compared to 2019, and a significant best efforts obligation to the same effect for scope 2 and 3 emissions. Well, concerning scope 1 emissions, I don't think it's overly revolutionary. Perhaps even not scope 2. Scope 3 is far less self-explanatory. Leaving the legal niceties aside, is this case, this type of cases, well considered? Perhaps it is, but it is not really obvious. I mention a few reasons. First, the war in Ukraine. In the meantime, we know we desperately need fossil fuels. I hate to say that, believe me. Is it effective? Well, Shell is doing much better than many of its competitors. If Shell stops selling fossil fuels, others who often do not a very good job will step in. And more importantly, many major oil companies can't be sued before courts where there is a favorable chance that they will grant useful relief, let alone that that relief will be enforceable against them. Arguably, alternatives might stand better chances. For instance, a focus on buyers, electricity companies, and emitters. Of course, I know, also in those instances, you will face difficulties, but it might all in all be a more promising strategy. I'm not saying that the Shell case is ill-considered. All I'm saying is we really have to think about those issues. More generally, we have to think about the potential consequences of cases and what will or may happen if the relief sought will be granted. And then finally, we must find a strategy to influence the behavior of those who can't be sued, or if judgments can't be enforced against them. And unfortunately, that goes for many states, that goes for quite a few enterprises. The Oslo principles and the enterprises principles offer a few solutions. Well, I admit they are quite radical. Just by way of example, Principle 20 of the Oslo Principles, states must make their best efforts to bring about lawful and appropriate trade consequences for states that fail to comply with the obligations set out in these principles. For practical purposes, we meant sanctions. The enterprise principles promote restrictions for buying products from enterprises based in countries that don't comply with their legal obligations in the realm of climate change. Again, of course, we realized this is quite something. It's perhaps too radical. There might be other solutions, but we really have to think about avenues to influence the behavior of those who can't be reached by court cases. They also must reduce their emissions, and we should be as creative as possible. These and many other questions need to be discussed at great length, and we can only be thankful to BIICL that it is willing to do so in this project. Thank you very much indeed.
Thank you very much. Yeah, that encapsulates things very nicely and brings us back to reality. There is a question from the audience, and I'm going to put that question to Richard and Jacqueline as asked. Let me see. Oh, it's answered. Oh, I see, Richard, you've already started to answer it. I'll read out the question, which is, thank you for your excellent discussion. A question for Jacqueline and Richard. Is it possible to draw inspiration or any lessons from asbestos litigation and Manus Island litigation in Australia and business and human rights litigation in the UK Vedanta case? So that's rather huge. But perhaps anyone who wants to answer that might refer also to the huge number of cases in the US drawing upon the tobacco lessons learned as well. So can I put that to, well, I think, Richard, you started. Do you want to start answering that? And then perhaps Jacqueline, because it's so Aussie focused.
Yes, it might be more for Jacqueline, but the answer is, as I say, it's a big question with no simple answer. I think some lessons can be drawn from other tort cases, although the analogies are not always close, and there are differences between climate change and things like tobacco and asbestos. But I think what is very striking is the relevance of documentation which may emerge showing corporations knowingly taking a risk of causing damage and continuing to do so primarily for purposes of profit. And that can be very relevant in the attitudes of courts. And so one of the most interesting things for me, who brought up a sort of black and white private lawyer, is the infusion of public law principles, whether they be intergenerational equity or general international law standards, into private cases. And so there was reference to some of the other cases, the public law cases. Yes, they will be relevant. Then Vedanta, slightly different point, but Vedanta looked at certainly English law questions of liabilities for subsidiaries, and that is clearly relevant to large corporations which operate as a group. And it was of some significance in the Shell case that the claim was brought against the parent, RDS, which in itself, it had minimal emissions, but it was found that because it set the policy, that its subsidiaries, direct and indirect, had to follow, it was an appropriate defendant. And I think Vedanta is important, both in terms of founding jurisdiction under the common law approach and in its examination of liability for subsidiaries. But I'll stop there, and Jackie may have some additional wiser thoughts.
Thanks, Richard. Thank you. Jackie, do you want to comment on that question?
Just very briefly, because I must admit I'm fading in this time zone, but just to say that I think in terms of where litigants are drawing inspiration from in the climate litigation field, it's from many different sources. So whether we're seeing cases against other sort of toxic torts, if we're seeing cases in human rights, or the Manus case is sort of looking at human rights obligations in respect of asylum seekers in detention. The history of climate litigation has been not just to use one tool, but to try many different tools over time to see what sticks. I think the other thing that's a similarity perhaps between the asbestos litigation and what might emerge in terms of cover major claims in climate litigation is the overall strategy, which is that there's a thought that there's a long-term game here that, and certainly with asbestos and tobacco litigation, it was not a successful claim first time out of the gates, but a succession of litigation gradually breaking down the barriers for the litigation, and then sort of one big win that sort of has massive ramifications through the system. And I think a lot of the test cases that are being brought in the corporate climate space that have a tortious formulation to them are looking at that same strategy, that many different cases could be brought, and you only need one breakthrough, one landmark to really create a ripple of effects, even globally.
That's great. Thank you so much, Jackie. Just before you disappear, you did make a comment, not in this forum, but on the BIICL website, where you say the project will be useful in identifying gaps. And I just wondered if you might want to say a couple of words about what gaps you think we might focus on in the project that would be helpful.
Yes, look, I might do that in a way that responds to one of the other questions that's in the Q&A, which also picks up on Richard's comments about where we might see more development that we haven't seen yet, which is cases in the Global South. So what we are seeing emerging in the Global South so far are human rights claims and more environmental law administrative claims. And so far, they're the ones that are achieving the most success. There doesn't seem to be as much scope for corporate law claims. I think that these will be more confined to parts of the developed world, but it is interesting to think about the possibilities for constitutional rights claims that might be brought against corporations. So in terms of gaps in our knowledge, I think understanding the mechanisms for action, the way that the toolbox might apply in the Global South is a very big area for further development of our knowledge.
That's absolutely brilliant. Thank you. Ivano, do you want to pick up the other question in the chat?
Yeah, sure. There is I go in order. There is a short and a very long question. So, yeah. So a very short question from Giulia Favero is on, okay, I have a question, which are the main grounds for litigation against companies in the UK? So probably for Richard. I mean, it's also a complex question. If you want, we can leave some time to think about this. And there is another question, which will be probably for Jaap. Let me just read it. In the Shell case, the Dutch courts also made some significant decision on applicable law applying the rules of round 2. The proposed corporate sustainability due diligence directive elevates the obligation included in the LCSDD to special mandatory rules, and is not only applicable to large companies located in the EU, but also to companies not so located if they trade in the EU. So threshold applying. The court in EU will be able to claim jurisdiction against EU-located company, Brussels IBIS regulation, but not against those not so located. So do you think the CSDD should include a jurisdictional clause in case of violation of the obligations under? Yeah, I say yeah, but yeah, who wants to respond also to this?
I'm terribly sorry, but I didn't get your question because due to the acoustics.
Ah, okay, sorry. Yeah,
Well,
it's in the chat. I've been sending to you. Richard, if you want to start with the others, so we give the time.
Well, while Jaap's reading that, just something briefly. Again, it's a big question. What are the main grounds in the UK? And often there is a climate change component in lots of different types of litigation. So there's lots of litigation that are effectively planning disputes over big infrastructure projects, whether they be power stations, airports. There was a lot of litigation about Heathrow expansion and so on. There are potential greenwashing claims. There are potential financial type claims of the sort Jackie was talking about, where people are sued for perhaps pension fund trustees or other fiduciaries. There are claims potentially against directors, and there's a claim going through against directors of Shell for dereliction of their duties, or it's certainly been started. There is, of course, always the possibility of a direct tortious claim, and there hasn't been much in England on that side yet. But there's a whole array of potential cases, some of greater significance than others. And a lot of, if you look at the Sabin chart, a lot of the cases are of relatively little interest globally because they're often judicial review type cases brought by companies or against governments in a way that affects companies for particular regulations. But that's a very quick canter through the sort of claims that that you might be able to bring. And I don't know if I'm allowed a shameless plug, but the Action for Justice Climate Litigation Toolkit gives a sort of snapshot of the ways you might look at that sort of thing. I don't know whether someone else wants to deal with things like Article 7 of Rome 2, but I'll stop for now unless someone wants to come back to me.
That's great. Thank you very much, Richard. Jaap, if you want to take on that.
Well, the answer is disappointing. I'm not an expert in that field. I don't want to comment on something I'm not really sure about. So it's a very good question, but I'm not the right person to answer it. Sorry.
Maybe we can take one of the others because there are three new questions. So one is always on the Global South. So is there any interesting climate litigation from Global South countries that claimants could use in court? So maybe, you know, yeah, anyone.
Well, the ones that I can't claim to have a comprehensive knowledge of everything that's out there, but I think there's been interesting stuff in Colombia, which was a classic example, the De Justia case, of a proactive order by the courts requiring a deforestation policy based on a whole range of factors relevant to climate change and liability. It wasn't a corporate claim. And similarly in India, there's been a great willingness for the courts to be quite proactive in a way that I think an English court would shy away from, and not just saying, well, this is unlawful, but saying you've got to do A, B, C, D, and E about it, and being really very specific. But I know as soon as I stop speaking, there are going to be hundreds of people coming in saying, well, you haven't mentioned the case in Peru or Nepal or the Philippines, but there's lots happening out there. So I'll stop there.
Just to add to
Yes.
that, if I may, Ingrid, just
Yeah.
to say, obviously, that the Global South is an enormous number of countries, obviously with very diverse legal systems, but the LSE climate laws of the world database does give quite a comprehensive view of the climate legislation that's emerging, and we are seeing a proliferation of climate laws, including in many Global South countries. I'd say, though, I'm doing a current project on Global South climate litigation. The trends that we're seeing are not actually around seeking to improve existing climate legislation, but instead to actually enforce existing environmental and natural resource laws often, or indeed to ask governments to implement particularly national adaptation policies. So it's a different kind of climate litigation that's emerging in many Global South jurisdictions compared to what we've seen as the sort of trajectory in the Global North.
Yes, and thanks, Jackie. And if people look at Pakistan and India, I think there's good examples there of what Jackie's talking about. I can see a lot of the questions are very legal and legalistic, which is perfectly understandable given the constitution of the panel. But what I would say is the project itself will be dealing with a number of the questions that have been asked around the risk-based regulation, the sustainability directives, and how effective they are compared to other legislative instruments and litigation and so on. So a lot of that will be coming forward. And so I think now we're going to be rounding off. If there are really compelling questions that you feel you want answered, please do email the BIICL email address, and we will attempt to get back to you. But I think we'll say a very big thank you to our panelists today and to Ivano for the project at hand, which is going to be huge. And we'll be seeing more of you. And stay tuned, I'd say, to the audience, because I think there's going to be some exciting and valuable developments over the next 12 months. Thank you all.
Thank you. Bye-bye.